You are witnessing a rare moment when the Department of Justice can no longer control the consequences of its own actions. Not a leak, not an indirect allegation, but a DOJ lawyer who voluntarily went to work on behalf of ICE in Minnesota, standing in open court and saying the one thing the system never wants spoken aloud. Julie Lee, an Asian American attorney, admitted during a public court hearing that she was concerned ICE itself may be engaging in racial discrimination and that it could directly affect her own family. Then she delivered the sentence that brought the courtroom to a standstill. This job is terrible. I'm overloaded, and ICE will not communicate with me or comply with the court's orders. When a government lawyer says that in front of a judge, the story stops being about administrative failure. The question becomes, who is actually in control of this system? In late winter, as pressure mounted across the federal immigration enforcement system, the U.S. Department of Justice authorized the temporary deployment of attorneys from multiple federal agencies to assist with a severely overloaded docket in Minnesota. Among them was Julie Lee, a career lawyer, not a political appointee, working at the Department of Homeland Security, DHS, who was detailed to the U.S. Attorney's Office for the District of Minnesota to support cases tied to detention requests from Immigration and Customs Enforcement, ICE. On paper, this was a routine internal coordination. In practice, it was anything but. Lee entered an office already stretched to its limits, where federal prosecutors were handling both criminal and civil matters while responding to increasingly urgent demands from ICE. She was assigned dozens of cases in rapid succession, many involving detainees already subject to conflicting court orders issued by different federal judges. Deadlines overlapped. Case files arrived missing critical documentation. Coordination between ICE, DHS, and the U.S. Attorney's Office was fragmented and unreliable. More critically, several federal judges in Minnesota had issued clear orders requiring immediate releases, orders that ICE was struggling or unwilling to execute on time. Then came the hearing. In a packed federal courtroom with remote access enabled and transcripts updating in real time, Lee, appearing as a representative of the federal government, was asked a direct question from the bench: why court-ordered releases had not been carried out as instructed. Her response was not defiant, not strategic. It was exhaustion, completely unfiltered. She acknowledged the workload beyond human capacity. She acknowledged the breakdown in interagency coordination. And in a moment that stunned the courtroom, she openly described the assignment as unmanageable. This was not a prepared statement. It had not been cleared by supervisors at DOJ or DHS. It was a government attorney in a public session describing internal dysfunction while attempting to comply with a lawful order from a federal court. Within hours, video clips circulated, headlines followed, and behind the scenes, emergency calls began inside the Department of Justice, because what Julie Lee said was more than an explanation for an administrative delay. It placed the federal government on the public record, acknowledging that court orders were being strained by policy pressures and enforcement mechanisms shaped during the Trump era, pressures that continued to weigh on the system long after Donald Trump left the White House. And that was the moment this stopped being a staffing problem or a workload issue. This is where the story changes. You don't see it explode on television. No emergency press conference, no shocking official statement. This crisis begins the way institutional crises in Washington always do, quietly, internally, and with calculated restraint. Just hours after a federal court hearing in Minnesota, alarms went off inside the civil division of the U.S. Department of Justice, not because the government had just lost a case, not because a complaint had been filed, but because something far more dangerous to a powerful institution had occurred. A government lawyer had spoken the truth, too plainly, too clearly, and directly into the public record. That lawyer was Julie Lee. The hearing where everything began was not a political spectacle. It was a habeas corpus proceeding where Judge Michael Blackwell, a federal judge in Minnesota, had to decide one of the most fundamental questions in a constitutional system. Does the government have the authority to continue detaining this person? And when Judge Blackwell realized that multiple court-ordered releases had not been carried out, he did not equivocate. He said plainly in open court, "These orders are not recommendations. They are orders of a federal court." That was not a threat. It was a reminder of constitutional order. Julie Lee, representing the United States government in that courtroom, was placed in an impossible position. She was not a policymaker. She did not control ICE. But she was the one standing before the judge, being asked the question every judge is obligated to ask: why are the court's orders not being followed? And then Julie Lee did the one thing the system never wants a government lawyer to do at that moment. She told the truth. She said the workload was unbearable. She acknowledged that she was handling dozens, possibly scores, of habeas corpus cases at the same time. She stated plainly that ICE was not communicating, not responding, not providing timely information that would allow her to comply with the court's orders. And then came the sentence that brought the courtroom to a standstill. She admitted her deepest personal fear, that her own client, ICE, may be engaging in racial discrimination, and that this raised concerns for her own family. She said to the judge, without qualification, "As you can see, Your Honor, I am not a white person. Judge Blackwell is African American. Julie Lee is Asian American." At that moment, the hearing ceased to be a legal argument. It became a raw confession about the breakdown inside the federal law enforcement apparatus, and that is where the Department of Justice's red line was crossed. Inside the DOJ, reflexive defenses immediately activated. Emails escalated up the chain. Written directives disappeared, replaced by closed-door phone calls. And suddenly, the focus of the internal conversation shifted. It was no longer, "Are we violating court orders?" It became, "Why was this said out loud?" Julie Lee had been placed in a structurally unwinnable position. She was instructed to represent the government, but given no authority to compel ICE to comply with judicial orders. When judges applied pressure, as they are duty-bound to do, every procedural shield collapsed. And when a government lawyer speaks the truth under oath, those words do not vanish. They become part of the record. They invite scrutiny, and they raise the one question DOJ fears answering publicly. When the executive branch defies court orders, who is actually in control of the rule of law? The system's response was not to fix the underlying failure, not to compel ICE to comply, but to contain the damage. Julie Lee was quietly removed from the assignment. No public discipline, no public defense, just an administrative reassignment, as if the problem had been resolved. But the record remained. Other judges began asking questions. Defense attorneys cited Julie Lee's statements in subsequent filings, and reporters began to identify a pattern that could no longer be ignored: delayed releases, missing paperwork, and a growing gap between judicial commands and executive action. The Department of Justice attempted to frame the incident as an individual lapse, a single overworked lawyer, a temporary staffing issue, but the deeper truth could not be buried. This culture of conditional compliance did not emerge by accident. It is a legacy of the Donald Trump era, when resistance to judicial oversight was normalized, and a change in administration does not automatically erase those institutional reflexes. Inside DOJ, this episode was almost certainly reported to the highest levels, including the Office of Attorney General Merrick Garland, where officials understand that institutional legitimacy does not come from winning cases, but from obeying the courts. Yet there was no corrective statement, no acknowledgement of failure. Silence was chosen as the strategy. And in this context, silence is not neutrality. It is a political choice, because when a government lawyer tells a judge on the public record that compliance is collapsing, and the system responds by removing the messenger instead of fixing the problem, the story stops being about Julie Lee. It becomes about whether the rule of law in the United States is an absolute principle or merely an option, exercised when convenient for the executive branch. And once that question enters the public record, it no longer stays confined to a single courtroom in Minnesota. It spreads. By that evening, the reaction splits into three predictable lanes: institutional damage control, political predation, and public recognition that something is slipping. Inside the Justice Department, the first instinct is not outrage. It's containment. Senior officials don't dispute what Julie Lee said. They dispute that she said it in open court. The internal line becomes a familiar bureaucratic lullaby. Isolated incident, miscommunication, temporary staffing strain. In other words, please look away while we patch the hull, but Congress does not look away. Congress smells blood. House Judiciary Chairman Jim Jordan announces a rapid oversight review, calling for transcripts, internal emails, and communications between DOJ and DHS. He frames it as proof that federal power is being misused, while quietly enjoying the fact that the damage lands squarely on the Justice Department's credibility. On the Senate side, Chuck Grassley leans into the whistleblower posture, not necessarily defending Lee's wording, but defending the principle that government lawyers should not be punished for stating operational truth under oath. And this is where the tension gets sharper. The question is no longer immigration. The question is obedience. If a judge issues an order and the executive branch cannot or will not comply on schedule, the system starts to look less like a constitutional republic and more like a negotiation between branches. Cable news does what cable news does. It turns a transcript into a morality play. Some anchors describe Julie Lee as a public servant in impossible conditions. Others call her unprofessional, a rogue attorney, or, my personal favorite, emotionally compromised. The same people who demand law and order suddenly discover that tone matters more than compliance. And social media. Social media immediately finds the subtext. A government lawyer accidentally saying the quiet part out loud. The public doesn't argue about docket management. The public argues about whether courts still control the executive branch or whether they merely request. International observers react in a colder register. A few foreign outlets frame it as another sign of U.S. institutional volatility. A country that lectures the world about rule of law now broadcasting in real time its internal struggle to enforce court orders. Then comes Donald Trump. Trump does not treat this as a human story. He treats it as ammunition. In a statement posted within hours, written in his signature blend of grievance and certainty, he casts the hearing as proof that the DOJ is corrupt when it targets him, incompetent when it governs, and dishonest whenever it speaks. It's the same maneuver every time. Degrade the referee, delegitimize the rules, and insist the only real truth is his. Now here's the critical part. Trump's reaction isn't just messaging. It's a warning shot to every institution watching. If you admit weakness, I will weaponize it. If you hide it, I will claim you're lying. That's not politics as usual. That's governance by intimidation. So ask yourself, because this is the moment you need to pay attention. If telling the truth in court triggers retaliation, what does that do to the rule of law the next time the stakes are higher? What happens next will not be loud, and that is precisely what makes it dangerous. If this precedent is not stopped early, the most likely scenario is this. Federal courts, starting in Minnesota, will stop trusting verbal assurances from the executive branch. Judges will no longer ask, "Are you complying?" They will move to a far harder question. Prove it. That shift means increasingly detailed compliance schedules, timelines, written confirmations, signatures from responsible officials, and a deliberately constructed paper trail. When a judge begins doing this, they are not preparing for mediation. They are preparing for accountability, including contempt findings, personal sanctions, and, in extreme cases, enforcement orders that force the executive branch into a public choice, comply, or openly defy the court. At the same time, the Department of Justice's reflex will likely continue along a familiar path, swapping personnel, tightening messaging, standardizing language, minimizing speech risk. On the surface, the machinery will appear more stable, but internally, a quiet effect will spread. Self-censorship. Government lawyers will absorb an unwritten lesson. Say less, speak more safely, be more evasive. Not because they don't know the truth, but because they understand the cost of telling it when it exposes systemic failure. If this trend persists, the DOJ doesn't just lose morale, it loses the most essential asset of a rule of law institution, the ability to speak truthfully in court. Politically, this issue is unlikely to remain confined to one state or one case. Congress, especially oversight and appropriations committees, will broaden the inquiry. How many federal court orders are being delayed in practice? How many difficult-to-execute cases reflect capacity limits, and how many reflect choice? When those questions attach themselves to funding, power shifts quickly. In Washington, there is no leverage stronger than money. Outside the halls of government, repeated delays will exact their toll where vulnerability is greatest. Detainees remain in custody for days or weeks after release orders. Families lose jobs, children wait, communities react. Each individual case can be dismissed as an administrative issue, but taken together they produce a collective realization. Courts issue orders in one direction, and the government executes in another. The most dangerous outcome is the long-term one, normalization. If the public comes to accept that federal agencies can struggle to comply with court orders as a routine matter, the constitutional system does not collapse dramatically. It erodes quietly through indifference. The rule of law does not disappear. It becomes conditional. And when that happens, the first people to pay the price are not those with power. They are the people without skilled lawyers, without political voice, without the ability to wait. The wealthy experience delay as an inconvenience. The powerless experience it as an undeclared punishment. If this trajectory continues, the question will no longer be about one lawyer or one hearing. It will be the question the system eventually must confront. In real-world practice, is telling the truth in court still protected, or has it become a professional risk? And if the answer tilts toward the latter, then it is not only government lawyers who are in danger. It is everyone who may one day stand before the government and expect the courts to stand on the side of truth. Now, this is the critical part. What happens next will not be decided by a Justice Department press release or a calming statement from the White House. It will be decided by deadlines set by U.S. District Judge Michael Blackwell in Minnesota, and deadlines that both the executive branch and political leadership genuinely fear. The most immediate path forward runs through the judiciary. Judge Michael Blackwell is likely to tighten the compliance regime again, then present an unavoidable fork in the road. Either the Department of Justice, under Attorney General Pam Bondi, produces named responsible officials, clearly documented implementation steps, and verifiable release confirmations from ICE, or the court moves from supervision to sanction. And once contempt of court is on the table, this stops being an immigration matter. It becomes a constitutional confrontation, the judiciary asserting its authority, and the executive branch, from DOJ to the Department of Homeland Security under Secretary Kristi Noem, and further down to ICE under Director Todd Lyons, testing how long it can delay before being forced to make a public choice, comply or openly defy the court. This is the moment when everything truly shifts. The record already exists. The hearing transcript containing the words of DOJ Attorney Julie Lee already exists. Public attention already exists, which means Judge Blackwell does not need to prove institutional dysfunction. He needs only to ask a single question repeatedly until it is answered honestly. Is the government complying with the court's order right now? On Capitol Hill, the next move is predictable and ugly: oversight weaponized. In the House, Judiciary Committee Chairman Jim Jordan will likely attempt to turn Julie Lee into a symbol of DOJ incompetence or bias, whichever framing best serves his political messaging. In the Senate, figures like Chuck Grassley will frame the episode as a test of protections for truth-tellers inside the government, while Senate leadership, John Thune and Chuck Schumer, quietly calculates whether this could escalate into a budget standoff, an oversight showdown, or a contempt fight. Both sides will demand documents. Both sides will quote selectively, and somewhere beneath the political theater lies a very real danger, that compliance with court orders becomes a political bargaining chip rather than an unquestioned baseline of the rule of law. And this is where the story turns again. If the DOJ senses a spreading political firestorm, Pam Bondi may opt for a hard reset, an internal review, a public statement about process improvements, and, most consequentially, a quiet decision to distance the department from Julie Lee, the attorney who spoke the truth in open court. If Lee is publicly disciplined, backlash from bar associations and former DOJ officials will be immediate. If she is quietly reassigned with no explanation, the effect may be just as corrosive, silence functioning as a warning. And then there is Donald Trump. Trump's familiar move will be to fold all of this into a larger narrative. DOJ out of control, courts politicized, the system rigged. He will use the very dysfunction now exposed to argue that the government, especially the Justice Department, has no legitimacy to judge him in any case touching his personal conduct. It is the oldest trick in modern American politics: destroy trust in the referee so penalties stop mattering. So this is the question that must be asked now. If the executive branch can turn compliance with a federal judge like Michael Blackwell into an operational negotiation, what happens when the next deadline involves election certification, a mass protest injunction, or a subpoena in a case directly involving Donald Trump? Watch what happens next very closely, because the next step will not just be legal. It will reveal whether the country still agrees on what the phrase "obey the court" actually means. So here we are. Not at a moment of explosion, not in a crisis announced on cable television, but at a point that is very familiar in the history of institutions. A moment when a system reveals itself unintentionally but irreversibly. A government lawyer walked into a federal courtroom in Minnesota to do what should have been a straightforward task: represent the United States of America. She left behind more than an awkward transcript. She left behind evidence of a system under such strain that those tasked with defending it in court are forced to explain conduct they themselves do not fully control. That is when the line was crossed. Not because Julie Lee was tired, not because she said something improper, but because from that moment forward, the story was no longer speculative. It was on the public record. Court orders issued, compliance delayed, internal friction acknowledged, and the familiar institutional reflex not to correct the failure, but to manage the damage. In a functioning democracy, this is not a side story. This is the center. Because when a government begins to treat court orders as variables, things to be managed, coordinated, or worked through on its own timeline, the rule of law stops being a binding principle. It becomes language, and language does not protect people. Only constraint does. This is a moment that demands attention, not because it is dramatic, but because it is instructive. It teaches agencies where their real limits lie. It teaches lawyers what honesty under oath costs. And it teaches the public something very simple and very unsettling, that even in open court, truth can become inconvenient to power. And if we accept that as normal, if we dismiss it as just a bad week, just an administrative failure, then we are not merely overlooking a story. We are acclimating ourselves to a precedent, because the real question is not whether democracy is noisy. The question is whether, when a judge issues an order, the government still feels bound to obey it. That is the question worth remembering, long after this video stops playing.